Okay, looks like we're ready to begin.
Good morning.
Morning, Your Honors.
So we had a little bit of a storm front in Cincinnati overnight. So it's good to see everybody safe and warm. And I'm glad that you were able to join us today for our oral arguments. We have 3 cases scheduled for oral arguments today. We're going to be taking one of the cases out of order. And so the first case that we will be hearing today is State v. Gonzalez, case numbers C190344 and 345. If both attorneys can please state their names for their record, their readiness to proceed as well.
Yes, my name is Kimberly Kendall Corral on behalf of Alexander Gonzalez.
Morning, Your Honors. Keith Sauter on behalf of the state.
Okay. And Attorney Corral, would you like to reserve time?
Yes, I'll reserve 4 minutes, please.
4 minutes, okay. Whenever you're ready.
Thank you, and may it please the court. I think this appeal is pretty straightforward, and it appears that the state has conceded the first issue, so I want to focus on the second issue, which has to do with the timestamp. Obviously, this appeal on the face of the filings was.
I mean, have they conceded it in light of, you know, the Ohio Supreme Court, Harper and Henderson?
Well, I think their exact statement is this lacks the proper language for imposing post-release control. The matter needs to be remanded to the trial court. Henderson makes clear that a judgment can only be challenged in direct appeal unless it's a question of jurisdiction. And the second issue in this case raises a question of jurisdiction. So I believe that notwithstanding Henderson, the issue, the concession is still legally accurate and valid.
Following up on Judge Zayas's question, if it's voidable and not void, doesn't that implicate your argument and the state's concession?
It does not. It is not voidable. It is void. There was not jurisdiction to hear this appeal. And Henderson.
Sorry, I'm not asking about the other assignment of error. If all we had was the PRC issue, there's jurisdiction there. You're saying there's not jurisdiction for a different reason.
Correct, but we can't parse them apart. They're all part of the same judgment entry. They all arise out of the same judgment entry, which doesn't meet the form required by the rules and required by the Ohio Supreme Court. And so to that point, the language by the Ohio Supreme Court interpreting Rule 32C is very clear. Initially, the Ohio Supreme Court addressed this matter in State v. Baker and then addressed it again in Leicester. In Leicester, the court said that judgment entries shall meet the form requirements set forth in 32C and that they are not final appealable orders unless they do. And we know shall means shall. The language in Baker, I agree, was ambiguous. I believe it said that an entry has to be journalized. But when the Ohio Supreme Court took up the issue again, they said, we modify the holding in Baker. We hold that a judgment must contain the fact of the conviction, the sentence, the judge's signature, and specifically says the timestamp indicating the entry upon the journal by the court. This entry does not have a timestamp.
Well, what do you say the box in the top left-hand corner that says entered 12-10-01, image 376? Isn't that it?
No, it's not a timestamp merely because the state says it is. We've all been working with courts long enough to know that a timestamp is made by the clerk. It is in fact a stamp, and it by requirement includes the time. If we just look at
Hamilton County, isn't that the clerk's entry? That's not the court's entry.
No, it's not. If we look just to the filings in this case, for example, that are in the record, and we look to what was filed in the clerk's office, we can see here in the reply brief of the defendant appellant, there's a time stamp on there. Clerk of Courts, Hamilton County, Common Pleas, 2020, February 28th, PM, 12:38, filed. That is the necessary component, the time stamp that is required. That same time stamp is in the other journal entries in this case at the same period of time, but it is absent from the judgment entry for Mr. Gonzalez's sentence.
Is
Now-
the one that you just referred to, the timestamp you just referred to from the year 2020? Is that the,
Yes, but it is the same. If we look to the record in this case, other entries in the journal, they contained an actual time stamp. There's not a,
so entries from the same year as this judgment entry had actual timestamps?
correct,
Okay.
actual time stamps.
It
The
appears
timestamp
on the
is-
docket, doesn't it? Isn't
I'm
it,
sorry?
if you go to the Clerk of Court's website, it appears as if it's docketed, doesn't it?
Yeah, that's not sufficient though. The Ohio Supreme Court modified Baker to say that journalizing it, they modified the language from journalizing to a timestamp.
But I
Specifically,
guess if I can just follow up, why is the entered date and image obviously is the scanning when they scanned it. Why isn't that sufficient for a timestamp? It's got
Doesn't-
the date,
doesn't-
it's made by the clerk, not the court.
how do we know it's made by the clerk, not by the court?
'Cause I was a common pleas judge in Hamilton County and the court doesn't do that entry, the clerk's office does. I mean, maybe it's not in our record, but
So I think that's the point though. We can't go by your personal experience. When we look at a regular timestamp, as is here, it says clerk of courts. One thing this doesn't contain, inherent in the term timestamp, is the time. A timestamp always includes the time. Those stamps were those giant stamping machines that all of us are familiar with our experiences. They weren't invented in 2002. I mean, that is technology that is minimally 50 years old. So the notion that there was some other timestamp, that things were handwritten, this merely documents the date in which someone entered it into the journal, but it doesn't indicate who entered it. It doesn't indicate when it was filed, what date it was filed, or a timestamp, and the timestamp is required. There is no such thing as substantial compliance. When we look, for example, at State v. Pless, which deals with a capital case that they reversed because the waiver of a jury trial was not timestamped. Now they say it was not filed with the clerk, but indeed it was in the clerk's file. It contained no timestamp though. So absent a timestamp, there's not any evidence of when it was filed. And
and
this
the date above that box, your position is that's not sufficient either. That says date, code, general judgment entry, Judge 109.
No, the Ohio Supreme Court does not at any point say you meet in form if you just type the date, but do not have a timestamp. It requires specifically a timestamp from the clerk of courts. I don't know who typed that date. I don't know what that date indicates. There's
Well,
not.
I don't think it's typed. I think it's stamp. It's a stamp that goes before it's scanned. But I mean, you're saying no matter what it is, that's not sufficient because there's not a time
It's not
as
a
opposed to a
timestamp.
date.
It's not a timestamp, correct?
And so
And-
ultimately, the remedy you're seeking is a resentencing because there's not a timestamp?
Correct, because this court never had jurisdiction to hear his appeal in the first place. This is not, if we look to a case like State v. Pless, where they overturned a capital trial because a jury waiver was not timestamped, the court is abundantly clear that there is no such thing as substantial compliance. And again, that may deal with a jury waiver, which is a separate statute, but it indicates the seriousness with which the court views a timestamp. That was in the clerk's file. It was not in the trial court's file, but it was in the clerk's file, but there was no indication of when it was filed because there is not a timestamp. And we know that the term timestamp is important because when the Ohio Supreme Court dealt with this issue a second time from Baker to Lester, they specifically say we modify our holding in Baker, and they change the language from entry in the journal to a timestamp by the clerk of courts. This form is entirely absent a timestamp by the clerk of courts. And therefore, the First District never had jurisdiction to hear Mr. Gonzalez's appeal. And if we take the state's position that merely writing a date in a box on a form is a timestamp, then anything can be predated, postdated, changed. The point of a timestamp is the date cannot be altered. It is stamped when it is stamped.
So if this really is a stamp and not, as you suggest, typed in, the clerk's office put in, your position would be it's still insufficient because there's not a time on it. There's only a date.
It doesn't indicate that it was done by the clerk of courts. It does not indicate the date and time that it was received, and it does not indicate the date and time that it was filed. A timestamp serves a function. It puts the defendant on notice of when something is filed with the clerk of courts, not when it's entered into the journal, but when it is filed. And we don't know when this was filed. We know when it was entered.
So your position is the defendant did not know he had been sentenced?
No, that's not my position. My position is that this journal entry does not meet the requirements under 32C, which have been expressly and repeatedly interpreted by the Ohio Supreme Court. The language is clear. And if we were to argue that there's some ambiguity, to which there is not, but if we were, the rule requires us to take the plain meaning of a word, and the plain meaning of the word timestamp is that it would include minimally the time. And in fact, if we look to every other filed item in Hamilton County, we see that the timestamp is of a consistent form, that it identifies the clerk, that it identifies the date, that it identifies the time, and that it says filed. And that is what is necessary to meet the requirements. The Supreme Court was so serious about this matter that they reversed a capital case in the matter of State v. Pless on the issue of a timestamp. That they said this, in Lester, they say shall means shall, that we modify the holding, and they modify it to include the word timestamp.
Can I ask you on your first assignment of error, can you talk a little bit about that, the post-release control?
Post-release control, the statute requires that post-release control, that a defendant be advised of his post-release control and sentenced to mandatory post-release control at the time of his sentencing. That did not happen here.
So
That
was
was-
post-release control discussed at all at the sentencing hearing?
No, it is in the
It just
judgment.
ended up on the judgment entry.
Correct.
Okay.
Ms. Corral, I know I've asked you many questions about this, but I have one final question. The barcodes that appear on the judgment entry from back in 2001 that have been entered on there, the one on the right and then the one on the left, it's your position, I assume, that I'm just trying to understand what you think has to be there. It has to say clerk of courts, even if those barcodes are the clerk of courts, and even if it shows the time on it, you know, if you put that barcode in.
Yeah, yes, Your Honor. And it's not what I think has to be there. It's what the high court in this state says has to be there. It doesn't say anything about a barcode. It says time stamp. And I think whether we use our common sensibilities, whether we use our experience with the court, whether we look at the prior and other filings in this very record, we can all differentiate a timestamp from a barcode. I don't see the word barcode anywhere in 32C or in the.
Your position is there has to either be a physical stamp with a date on it or something that went through an automated system that has the date readily apparent on the face and not by looking at the underlying barcode.
That is what is required by the Ohio Supreme Court in its interpretation of 32C. Correct.
Thank you, counsel. I'm going to reserve your time. Attorney Sauter?
Yeah, may it please the court, counsel. I think I'll start with the second assignment of error. I think the problem here is that the appellant is arguing that there is no final appealable order in this case. If the order wasn't final originally because of the absence of a timestamp, it's still not a final order. And this court, as counsel has said, lacks jurisdiction over the matter. The only remedy would, at this point, would be dismissal of the appeal. This court lacks jurisdiction. At that point, it would be up to the up to the defendant in this case to file a petition for a writ of procedendo or mandamus to compel the court to do what it had to do under their theory of the case. Absent that, if we accept Ms. Corral's argument at face value, the only thing this court can do is dismiss the appeal. It can't order a resentencing. It can't do anything else with respect to the judgment because it's never a final order under their own argument. As to the first assignment of error, I think technically probably under Fikes and Harper that this is probably a voidable sentence. The state didn't update its brief, and I apologize for that. My argument would be that under Fikes and under Harper, that the trial court had jurisdiction over the subject matter. The trial court had jurisdiction over the person, so that the imposition of post-release control at the time of sentencing was proper. Any deviation from the statutory requirements would have to be raised on a direct appeal at that time. The fact that it wasn't, it renders this voidable, not void. And I think it's res judicata. But as I said, the state did not update its brief. We haven't cited State v. Harper, which was decided after our brief was filed. I think mainly, probably because we wouldn't really object to a resentencing on just that basis to have the notification done.
But I thought he wasn't sentenced at all to post-release control, and it just like by mistake ended up in the judgment entry.
Well, that's my point. It's in the judgment entry. As part of the sentence in this case, the defendant is subject to the post-release control supervisions of RC 296728. So there's no doubt that it's in the judgment entry. What the state concedes is that it wasn't properly done at the sentencing hearing, and the proper notifications under Fikes and the other and statute was not included in the sentencing entry itself. The provision for post-release control is in there. It just doesn't include the required statutory notification about the details of post-release control.
Mr. Satter, let me ask you to address something. Counsel's position is because there's not a time, 10 a.m., 5 p.m., that makes it invalid under the Supreme Court's precedent. I note that no judicial filings in this case, and maybe in any in Hamilton County, ever have a time. It does if a party files it, but if the court files it, it never has a time. What do you say to that? Are all Hamilton County entries void because they don't have a time?
I'm sorry, Judge, I didn't mean to talk over you. No, I think that's the conclusion the court would have to come to. I think this is, it's a ministerial act that it doesn't include the time. I think I understand Ms. Corral's position that the Supreme Court has been clear about this, but really what she would be seeking is the invalidation of everything that occurred in this case, in which case, of course, there would be no final appeal order. The only thing this court could do would be to dismiss the appeal.
Well, the second part of Attorney Corral's argument is that there's no clear indication that the stamp is from the clerk of courts. How would you respond to that part of it?
I concede that. It's just the way that our clerk does this, and if this court finds that it hasn't been sufficient under the criminal rules, then I think that's something the court will have to decide. I can't. There's nothing I can do to defend the clerk's practices in this case, or to argue that what it did was proper or improper.
Are we able to take judicial notice that that stamp is the stamp that would have been procured through the clerk of courts at that time?
I don't know what else the court could do. I mean, there's nothing outside of the record to indicate one way or the other. So that would be up to the court to decide whether or not to take judicial notice of that, or to, how it would handle that, because there's nothing to horse the record to indicate what the clerk's practices are, or what would suffice in the regular case.
Well, I don't know how we make that determination. I mean, I don't know if that's on the prosecution to provide to us, but maybe it's on the defense to give us some kind of information that this is not an actual clerk stamp. I don't know how we as a court determine that this is not a clerk of courts stamp.
I think that's the crux of the issue here. I think that on its face, it appears to be proper. And if it's not proper, this court lacks jurisdiction. So there's really no way this court could reach the issue if it found that this weren't a proper stamp.
Well, if this isn't a proper stamp, then there's no conviction in Hamilton County. I don't think the times are on it. So I guess that's, we've never held that before, obviously, but.
My argument would be that it's sufficient. I think what the clerk has done is indicated when it's journalized. The journal here indicates that it's been journalized. I think that's sufficient under the criminal rule. If it's insufficient under the criminal rule, this case has to be dismissed and start from scratch.
Do you have anything further, Attorney Sawyer?
No, nothing, unless there are questions, Your Honor. No,
Okay,
thank you.
any other questions from the panel? Okay, thank you. Attorney Corral?
Ms. Corral, can I start with my question? Because I did have a chance to go look at just some other things. Convictions in Hamilton County, I don't think ever have a time stamp, a time. I mean, they have a stamp, it says entered and a date, but never an exact time. Is it your position that those are all void? And that
I can't take a position on something I've never seen, but I think if you're conceding that the other ones have a stamp and this one does not, that it
No,
says
I'm
entered.
sorry. No, I'm sorry. They have the same barcode. They have the, some have entered like the other entries did, but just the same date, no time. Is your
Is
position
that in the
it
Court of
means
Appeals or is that in the Hamilton County Clerk of Courts?
Hamilton County?
The Court of
Oh.
Appeals stamp does not have a time, but everything I've looked at from the Hamilton County Clerk of Courts does, but I can't comment on something outside the record that I've not seen. One, I generally practice in Cuyahoga County, so I have less experience looking at Hamilton County dockets. But
Let me
the
have
fact
you
that
look at
other,
this. I'm sorry. Let me have you look at this docket. Other entries by the court, none of them have times. Would you agree with
they are
that?
required to have a time stamp by the Clerk of Courts. If they do
I'm
not,
asking you though, it doesn't, none of them do, right?
the
Might have
language
an entered with
timestamp,
I'm
sorry. All I can tell you is the language timestamp on its face requires time. I'm not challenging every conviction in the history of Hamilton County. I'm challenging this one, which has no stamp, no time, no indication that it was received by the Clerk of Courts, no indication of when it was filed. And I think the state conceded that. I know my time is short, and there's one thing that's very important to address, and that's the state's position that the court can't hear this appeal. In fact, that is not correct. What we're appealing now is the November 21st, 2018 denial of the motion to vacate sentence. This court absolutely has the jurisdiction to hear an appeal on that matter.
There's not a timestamp on that entry.
There is. It has a Clerk of Court stamp on it. I'm
It
looking
doesn't
at
have the time. I thought you said the time had to be there,
it has
Is
a
it-
Clerk of Court stamp of when it was entered.
but no time of when it's
If
entered.
this is the Clerk of Court's timestamp, then what we've done is make the case that the original judgment entry, in fact, does not have the even the insufficient timestamp which is used by the Clerk of Courts in Hamilton County. I think
I'm
what
sorry,
we've found is Hamilton County has a timestamp. It may be insufficient because it doesn't contain the time, but even that insufficient timestamp was not used in the sentencing entry in this case.
But your position is we do have jurisdiction, even though there's no time on that entry because we don't care about the time? If there's not a time, and I'm not talking about the entered stamp, do we have jurisdiction of what you want us to hear if there's not a time on it?
An entry requires a timestamp by the Clerk of Courts.
And so if there's not a time on the entry from November, we don't have jurisdiction.
I believe that this stamp is insufficient. Under the law, the language is clear that a timestamp is required.
The November 2018 stamp on the entry overruling the motion to vacate, you're saying is insufficient?
Had the state wanted to raise that issue on cross appeal, they could have done so, but that is not the issue before the court now. We are challenging.
If we don't have jurisdiction, we don't have jurisdiction.
What party raised that in this case as to this judgment entry?
Well, we've held in the first district that it doesn't have to be raised by a party. If we lack jurisdiction, we lack jurisdiction.
Then the entire case from the beginning needs to be dismissed.
And that was the point of Attorney Sauter, because I wanted to clarify that and have you address it that way. What he is saying is if the sentencing entry is not a final appealable order, then that means that anything that flows thereafter, there's no jurisdiction for that to be heard.
Incorrect. The procedure for challenging a void sentence is in the trial court. Mr. Gonzalez challenged this void sentence in the trial court. The trial court erred in overruling it, and that entry is appealable.
I
Okay,
think
thank
what
you
we're
for-
trying to figure out is, in asking you about the November 2018 timestamp, if what you're wanting us to do is you want us to say the timestamp on the judgment entry was improper because here's the reasons why. We don't know it came from the clerk of court. There's nothing on it to show that it came from the clerk of court. There's no actual time. Now, if we look at the entry on the order that you're appealing in this case, all it says is entered and a date. Doesn't say clerk of court, doesn't have a time. So, I mean, if we make a declaration of what you're asking us to make, then we are also going to be saying that the order that you're appealing is
I'm asking you to follow the law as expressly set forth by the Ohio Supreme Court, interpreting the rules. If Hamilton County has made some misstep, which renders every single judgment void because this appellate court lacks jurisdiction, that's not what I've raised in this appeal. So I'm not prepared to address whether every single entry in Hamilton County is in fact void. The entry which my client is sentenced under and has served 20 years of a sentence under is void under the law by any interpretation set forth by the Ohio Supreme Court.
Thank you, Attorney Corral. Thank you for both of your arguments this morning.
Thank you, Your Honors.
Thank you.
We'll take the matter under submission and we will issue you a timely decision, and have a wonderful and safe afternoon.
Yeah.
Good morning.
Morning.
Good morning.
Morning.
The next case that we have scheduled for argument is Wells Fargo Bank versus Patrick Shear and Sandra Shear, case number C190466. If both parties can please identify themselves and their readiness to proceed, please.
This is Patrick Shear. I'm representing myself and my wife.
I'm Sandra Shear. Good morning.
Good morning.
Thank you.
Morning, Your Honor. Dan Gibson on behalf of the appellee.
Thank you. So, Mr. Shear, you're going to have 15 minutes for your argument.
Okay.
And you can reserve a portion of those 15 minutes so that you can rebut the argument of Attorney Gibson.
Okay.
Would you like to reserve a portion of that?
I'm not exactly sure. I've got so much information. I don't even know where to begin because
Okay.
This is not an easy straight.
Of course it's not. Yeah, I understand. So, I mean, you can, some people reserve 2 minutes, some people reserve 3, some people reserve 5 of the 15
Is there
minutes.
a possibility that I could, in the middle, see where I'm at and ask to be reserved?
Well, here's the issue with that, because if you use up your 15 minutes, you use up your 15 minutes.
Right. Okay. I'm trying to hedge my bet.
So what I would do, I mean, what I would suggest is, why don't you reserve a certain amount of time? Maybe you reserve 2 or 3 minutes, and, as you're getting into the argument, if you feel like, you know what, I think I'm done and I want to reserve some more, we'll carry that over and add to your reserve.
That sounds great to me. Excellent
Okay.
advice.
So what would you like to reserve?
How about 3 minutes?
Okay, so 3 minutes. And again, if you're, if you're done at 8 minutes, we will carry the rest over.
Thank you.
All right? So, Mr. Shear, whenever you're ready to proceed, you can start.
Okay, I was just gonna kind of give me a little timer here, to see where I'm going. Actually, this whole thing started with a note from Comey and Shepherd, and I've got their letter right here. And they stated from Wells Fargo, we had numerous times tried to put in for loan modifications, and we applied and applied and applied. I know that the other side says, well, you didn't make your payments. We offered to make payments. They refused because they said after 3 months, we can do whatever you want to do. And so we tried loan modifications. We finally decided to go and do a short sale. Well, Comey and Shepherd was handling the short sale. They went to Wells Fargo, and Wells Fargo wrote back and said, and here's the letter. You've got that in your file. If you go to February the 10th of 2020 in the one of our filings, Wells Fargo states, we are unable to locate the account that you're referring to. And this goes back to Comey and Shepherd. We were not even at the letterhead. We were as a CC, carbon copy of that letter. So then just recently in July, I wrote to Wells Fargo because every time I called, I mean, I can't even tell you how many times I called, and they would say, who are you? You know, we don't have any record of you. So then I think I've annoyed them enough, because banks do not, believe me, they do not admit to anything. And I got a letter on November the 19th, which you got in your last here. We have searched all systems of record and did not find where this loan was ever referred to or in foreclosure. We did not file suit against you. I go back here to, and that was on November the 19th, September the 8th. And this was in reference to the letter that I sent on July the 23rd. I got a receipt back on September the 8th. We are unable to locate the documents you requested, and the account may have been transitioned from Wachovia to the new servicer before we merged with Wachovia. So we know that Wells Fargo has no record of us, and they went with Wachovia in 2008. Wachovia actually went out of existence technically in 2008, but physically in October the 15th of 2011. On 2011, the bank was officially closed, and that was in Charlotte, North Carolina. Now, we come to the fact that supposedly there was a transfer of mortgage. That transfer of mortgage was done in June the 25th of 2014. Notice in 2014, Wells Fargo Bank or Wachovia Bank was not in existence. Now, when you take a line of ownership, you have to take from the, it goes from the Federal Reserve to Chase Bank. Chase Bank, they said they sold it to Wachovia. Wells Fargo got it. It says succession by merger to Wachovia. Well, Wachovia didn't exist. So you can't buy something from a bank that doesn't exist. That's where the fraud comes in. And that's why I put in fraud that you have in your case. If you have a shell company, it's called a shell company. And they do that to hide where you're going to put assets or whatever. This is a shell company. This is a company that does not exist. It did not exist in 14. So again, Wells Fargo could not have done, have put in a lawsuit. Now, Daniel Gibson should have known this. And he keeps stating, even to this fact, now comes Wells Fargo and a successor by merger to Wachovia Bank, NA. Well, this is false. That's a false statement. And he even put that in after I served him with a letter stating that that Wells Fargo never initiated the file, and I served him with exactly the same proof that you received. So they still, to this date, want to do a fraudulent lawsuit. Actually, there was 3 suits that were filed against us. My wife and I have really suffered huge damages. We've lost 4 companies, and a little over $1 million in doing that. So let's see, yeah, well, we had an 813 credit score at that time, and now it's down well below 600. So again, we frankly, we're infuriated by the way the attorneys have handled this, and it is Chase Bank. If you look at your files, you'll look again, February the 10th, go back, you'll see where I challenge Daniel Gibson's ability to stand in the court. And Daniel Gibson writes to me, Chase versus Shear. Here, Daniel Gibson writes to me, Chase has approved a $25,000 payment to you if you give up the lawsuit. I don't know if you have that, but I've got that right here. The last one, Mr. Gibson really did not want to be in the courtroom. He did not want to do oral arguments, and I can understand why. But would you please let me do a written brief? And again, Chase versus Shear. So we know really it is not Wells Fargo who is suing us. And so this case has to be dismissed on the fact that Wells Fargo is not in the courtroom. Chase Bank is. Chase Bank is not suing me. So therefore, this case should be dismissed. Now, we go to Gloria Bird, Wells Fargo versus Gloria Bird. And you've got the case number. It's C070890. In that case, Wells Fargo had not filed their mortgage before they filed suit. It was they filed one day after they filed suit. Your court dismissed this case because they did not have the mortgage. Our case, Wells Fargo does not have the mortgage. They do not have the note, and they didn't file suit against us. So I hate to say it, but it really should be a no-brainer that this case needs to be dismissed. All right, so now we go, let's see. We go
And I'm
to,
just, Mr. Shear, I'm just going to let you know, you have about 2 minutes of your initial 12 minutes left.
okay. We'll go to the dismissal by Mr. Smith. And again, it states that he actually dismissed his own case on his own. It says a 2A dismissal has to be upon the order of the court. There is no order given. Yes, he filed an A2, and that was a he filed to have the court dismiss the case. The judge did not grant that order. He went to the court and actually got it. Well, according to him, I'll read it right off of this. So we pay our check, we get stamp out, and we bring the order up to submit it to motion to dismiss. This is from actually Daniel Smith's transcript, so, or Nicholas Smith's transcript. So nowhere did he actually get permission to go and pay out with a check, close the case out, and get a stamp on it and submit it in a motion to dismiss. The case was already dismissed before it ever went to the judge. So as far as a double dismissal, yes, it falls under the double dismissal rule. And then here are documents that I submitted to you stating that after each one of the cases, each one of the times, and there's 2 cases that he went up and dismissed on his own, a unilateral dismissal, okay, a unilateral dismissal is classified as an A1 dismissal. 2 A1s is the double dismissal rule. He unilaterally dismissed his case both times. Unilateral meaning you go on your own and dismiss it on your own. He dismissed both of them on his own. So, and he did not have court's approval. It specifically states in my filings, what I pulled up on the dismissals, that you have to have that before you actually can be given the a 2A, and 2A then, you know, will let you file another lawsuit and not get the double dismissal. What he did was unilateral dismissals, and unilateral dismissals are A1, 2 A1s equal a double dismissal rule. I don't know if how I'm doing on time, but you know.
Well, you're pretty much at your time in reserving your 3 minutes.
Okay, good. And I'll do that. Thank you.
Okay.
I've tried my best. I like I said, there's more in this case. I could give you the whole thing, but you know, this is just touching the part of it.
Well, thank you. We're going to turn now to Attorney Gibson.
Mr. Gibson, if I could interrupt you before you even start, can you address during some course of your argument, his argument that your client did not comply with Byrd at the time it filed this lawsuit?
Certainly, Your Honor, I'd be happy to. And in fact, that is to the extent there are any issues properly before the court, that really is the only one. It's the only one he raised in the objection to the magistrate's decision. The 2 dismissals, although Mr. Scheer had not submitted any evidence or documentation of them in the trial court, I think it was okay for the trial court to take judicial notice of the fact that they were not unilateral dismissals. In particular, the second one was explicitly by motion, where it asked the court to dismiss it on its own, precisely because of the concern about the potential for 2 dismissal interpretations of, excuse me, that make it difficult for subsequent foreclosures, precisely because of the transfers and things that have, I think, caused a great deal of confusion to Mr. Scheer, understandably so, that different entities possess the note at different times. So I wasn't counsel in that, but foreclosure counsel was very explicit in their motion, asking the court to dismiss it by motion rather than unilaterally, for the very reason that he's described. But more generally speaking, apart from that being the only issue, and I don't know if that answered your question, Judge Myers, but.
Well, specifically, I think his argument is Byrd requires your client to be the holder of the mortgage at the time that the action is filed, and can't be, if I'm remembering Byrd correctly, can't be cured later by a transfer by a longe or otherwise of that interest. And I think Mr. Scheer was saying that at the time the foreclosure action was filed, your client was not a holder at that time. And I may have misunderstood his argument, but I think that's one of his arguments.
I was not aware of that argument. I understood it to be a 2 dismissal rule argument, but to the extent that that is his argument, I don't think that the record evidence demonstrates that. Though if I can look at the affidavit, obviously not having addressed this in the briefing at all, it hasn't been a subject.
Well, that's why I wanted you to address it first, because I heard him talk about Bird, and I think that was his argument. And if I'm mistaken, I apologize.
No, not at all. And I mean, I'm happy to try to answer that. The affidavit attached to the summary judgment motion, which was entirely unrebutted in the trial court, provides the chain of transfers and assignments. And I believe all of those well predated this particular foreclosure. And in fact, I think they predated the 2 prior foreclosures that were dismissed not unilaterally, but by motion. And so I don't think that there's any evidence to indicate that there was a holder problem. The evidence attached to the affidavit shows a note endorsed in blank with an affidavit statement that Wells Fargo is the holder. I understand Mr. Scheer's confusion about Chase. And in fact, as I indicated in one of my filings, I even misidentified them precisely because Chase is the loan servicer. I understand that for folks who don't practice law in this area, that's probably not a real helpful distinction, but the reality is that the loan servicers oftentimes are managing these loan files and cases, but they have the authority to file on behalf of the owner of the loan, as long as the paperwork demonstrates who the holder and beneficial interest owner of the note and mortgage are. But perhaps more importantly, in this particular appeal, none of this has been properly raised. None of it was certainly addressed at any point in the trial court. The only thing that Mr. Scheer raised in the trial court was suggestion that that Chase's, or excuse me, there I go again, that Wells Fargo's response to his objections to the magistrate decision weren't timely, and that the 2 dismissal rule barred this foreclosure from proceeding, neither of which are grounds for reversal. And in particular, the 2 dismissal rule argument is just simply wrong on the record. The rest, as we've said in our brief, the evidence attached to the summary judgment motion clearly satisfies the prima facie requirements for a foreclosure judgment. Mr. Scheer has not once here indicated anything about not having defaulted, not having owed the money. Obviously, he has a lender that he owed money to at some point for the purchase of the property. There's no dispute of that. This is largely in my opinion and respectfully, a misunderstanding that has led to a lot of theories that there is some kind of surreptitious, wrongdoing at issue here, when in reality, the paperwork attached to the motion for summary judgment is a straightforward demonstration of owner and holder status, entitling the plaintiff to judgment, and it is documentary evidence that has never been, in fact, contradicted by Mr. Scheer. So if the timing of the holder status and all of those other issues that he was mentioning about Wachovia and whatnot were the genuine subject of his quarrel with the judgment, he certainly could have raised those in his objections to the magistrate's decision, but they're nowhere to be found. It's entirely a 2 dismissal rule argument, which is meritless. I would suggest that more than anything, while there are a lot of things being said and a lot of, frankly, improper disclosure of a settlement communication, some sideways comments about my professionalism, that sort of thing. At the end of the day, the factual record and the law is very clear, and there was a default. The proper party brought a foreclosure. It was demonstrated to be warranted. The trial court agreed. The objections were meritless, and the trial court adopted the magistrate's decision. And this court has no reason before it to change that result. I'm happy to answer questions if any of the other judges have any, but I think that the briefing sets forth our position.
Thank you.
Thank you.
Mr. Scheer?
Yes, okay. he said the proper party went ahead and filed a foreclosure. Again, I go back to my last letter stating from Wells Fargo. If they're claiming that Wells Fargo is the lender, Wells Fargo claims they are not the lender. You've got the letter in your file. We did not initiate, nor did we, file suit against you. It also states we do not have the note, we do not have the mortgage, and so Mr. Gibson has kind of gotten it wrong because Gloria Bird case states that you have to have the mortgage, at least that they didn't have the mortgage, but here's Wells Fargo stating in a letter to you, they do not have the note, they do not have the mortgage, and they did not file suit against us. So, Mr. Gibson, this is definitely a fraudulent lawsuit that was brought against us. And as far as Chase Bank being the servicer for Wells Fargo, Chase Bank uses ASC. Wells Fargo uses ASC. That's the American Servicing Company. They bought out ASC. So all the home loans go through ASC and now go through Wells Fargo themselves. They did not use Chase Bank as a servicer. In the trial court, he said, I didn't bring this up in trial court. Well, no, I told you, I just found out in September, about three months after we went to appeal. And we filed for a short sale to keep it out of sheriff's sale. 2 times we had to go to sheriff's sale, and we blocked it from going to sheriff's sale. We didn't find anything out until Comey Shepard comes back and says, hey, Wells Fargo doesn't know who you are. So we started investigating, and those are the letters you have. We do not have the note. We do not have the mortgage, and we did not file suit against you, nor did we initiate the suit against you. So
What's the date of the letters that you're talking about?
that letter was, let's see, that was November the 19th, just off the top of my head. You have it in your file. The last filing that I did to you, and it was asking for a dismissal based upon the fact that I had those 2 letters. Those 2 letters are in there. Okay.
November 19th, 2020.
Right.
Okay.
And well, let's see, actually, yeah, November 19th, 2020. Right. So you're gonna test my mind. I'm an old. Don't do that to me. Okay, I appreciate. Thank you. But no. So basically, that's why I went with Gloria, the Bird case, because in that, I mean, that's settled law. If you do not have the note, you do not have the mortgage, and in this case, you didn't file suit against me, and this is a statement. Obviously, the case has to be dismissed. And then the fact that I want to get the double dismissal rule on there too, because this is going to be a matter of probably sometime in the future, people are going to look this up. But under the double dismissal rule, the way it has to happen, yes, and Mr. Gibson's right, they did file an A2. They filed a motion for an A2. Now, if I were to come to your court and say, hey, sorry, people, I closed your case out. I'm going to hand you a paper and I want you to go ahead and dismiss this case for me. Here's the paper. I want you to do that. I'm sure I would not get a very good reception, because a judge has to approve a motion. You take that motion, you go to court, and you get your payout statement. You show to the judge that that the case has been paid out. Then you take that paper up to the court and say, look, Your Honor, I followed your recommendation, which the Ohio Supreme Court says before you pay out your case, and you close out the case, you have to get permission from us. They did not do that. This is the little point that was mistaken. If you go and look at the records, there is no indication by the judge that he okayed that, what was it? Permission to go ahead and close out the case.
So
So
you're
he
saying
did
that
it-
the second dismissal, even though it purports to be an A2, is actually an A1?
It's an A1. It's definitely an A1. It's a unilateral dismissal. When you go in on your own, that's a unilateral decision to do something. You do it on your own. And he did not have the court's permission to do that. He went in on his own. He got the, as I said, it's in your file, exact wordings. That was in the initial brief that I put in. Daniel, that's actually Nicholas Smith's, and that's in the court record of September the 9th, 2019.
Thank you, Mr. Scheer. So I've given you about, you wound up with a couple of extra minutes to allow you to finish your thoughts, okay?
Don't get me going.
All right.
But I mean, this is it. I mean, and that's why I'm so, because I know this case has to be dismissed, and I want it dismissed for two reasons. One, again, they do not have the note, they do not have the mortgage, they did not file suit against us. Number two, the double dismissal rule comes in because he unilaterally closed out his own case.
Thank you. Thank you both for your arguments this morning.
Thank
Thank
you.
you, Your Honor.
And thank you for your patience in allowing for the docket to go out of order. And I wish both of you a wonderful afternoon. We will take the matter under submission and issue you a timely decision.
Thank you.
Okay, well, thank you. I
Thank you.
appreciate it.
Good morning.
Good morning. Okay, so we're both, okay, good. We both have cameras this morning. Very good.
I don't see Mr. Meyer. I'm
Okay,
assuming he's with us.
We can see him.
Okay,
You have yours on gallery view?
I do.
Oh,
Let me see if maybe I scroll off a little further. Oh, okay, I just didn't
Okay.
scroll far enough.
all righty. So we're here on the case of Fred B. Hamilton versus Louis E. Barth et al. Case number C200027. And before we begin, I just want to, I know that there's been a death, so I'm sorry for the loss for the family.
Thank you. Thank you.
So if both attorneys can please state your names for the record and your readiness to proceed.
This is James Neighbording on behalf of plaintiff Brad Hamilton, and we are ready to proceed, Your Honor.
Donald J. Meyer Jr. on behalf of Dorothy Barth and Andrew Barth, guardian of Louis Barth, and we are ready to proceed.
Okay. Okay, Attorney Nieberding, would you like to reserve some time?
Yes, please.
How much time would you like to reserve?
2 minutes.
2 minutes, okay, whenever you're ready.
All right. Just briefly, Your Honors, the claim was initiated based on a complaint seeking specific performance of a land installment contract between my client, Mr. Hamilton, and the Barths. Property is situate in Hamilton County. On May the 8th, 2018, the parties executed a document which is captioned as a land installment contract. It identifies the Barths as the owners of the property and the seller. It identifies Mr. Hamilton as the buyer. It sets forth the purchase price. It describes the property to be conveyed by the mailing address, by the auditor's parcel numbers, Attached to the originally executed document was a copy of the bar's current deed and a copy of a survey plat. There was no meets and bounds description. We can see that there are terms included in the document for a down payment, which of $500, the initial payment, which was received by the bars. There is a handwritten notation at the top of the instrument that it was received with the date of May 8th of 2018. It sets forth the terms for the balance, payment of the balance of the contract, periodic installments, and a balloon contract due May the 7th of 2025. It makes provisions for the payment of taxes and possession. And the Barths, in fact, signed it. I don't think there's any dispute about that. The document was not acknowledged in the presence of a notary, and it was not recorded.
And it's not disputed that it was not acknowledged. Is that right?
There is no dispute. It was
Okay.
not acknowledged.
And so you're moving forward on a breach of contract.
It is our position that the document, even though not strictly compliant with the statutory provision for a land installment contract, is enforceable as a contract for sale between the parties pursuant to the provisions of the statute of frauds. And though it may not be effective as a conveyance of real estate, it is effective and enforceable as a contract for sale of property.
But your complaint was on a breach of contract. You did not seek declaratory judgment. Is that correct?
No, I did seek the declaratory judgment. I included a breach of contract claim and a specific performance claim in the complaint.
So your position is you did seek declaratory judgment in the complaint.
Yes.
I apologize. My phone is giving me an Amber Alert. Apparently, those notifications are not turned off, even though everything else is.
But in essence, Your Honors, it is our position that the document complies with the statute of frauds and it's enforceable as a contract for sale between the parties.
Okay, so even if you did seek declaratory judgment, did you plead part performance?
I don't think part performance is applicable. Well,
You don't, I mean, you've conceded that there's no acknowledgement. So the default is you don't have a contract. So to get it out of that, wouldn't you have to be able to establish part performance?
no, I don't believe so, Your Honor. I believe the document as executed by the parties satisfies the statute of frauds and is enforceable because, number one, it identifies the parties, the consideration. I believe it adequately describes the real estate to be conveyed. And though defective is for the conveyance of an interest of real estate, I think it sets forth the essential terms of a contract for sale of the property. And
So then what would be the purpose of the statutes that govern land contracts that have shall language, if that's the case?
Well, it is, I would distinguish that as a conveyance of real estate, which conceitedly the document is not acknowledged and it is not recorded, which is required for recordation and transfer of property. But there is authority in the state of Ohio, Citizens Bank versus Dennison, that a defectively executed instrument for conveyance of property is effective or enforceable as a contract between the parties for sale. And the requirements for a contract
And
for sale.
in that case, well, that case involved the lease, did it not?
Yes.
Okay, and
No,
wasn't the lease,
the Citizens Bank, I believe, was a mortgage foreclosure.
okay, and wasn't that mortgage in effect for quite some years before
Yes.
the lawsuit ensued?
Yes.
So isn't by default, wasn't there part performance there, even if not discussed within the case?
I think the case, yes, there was an element of part performance.
Okay, and let me ask you a question that's not briefed by either party. There was a counterclaim for slander of title.
Yes.
Is that correct? Okay.
Yes.
Did the court dispose of that counterclaim?
I do not believe the court did.
So do we have a final appealable order?
I believe we do, Your Honors, based on the language of RC 250502B. It says an order is a final order that may be reviewed if it affects a substantial right in an action that in effect determines the action and prevents a judgment.
But if there's more than one party or claims, doesn't there have to be Rule 54B language in there to make it a final appealable order? If claims remain pending?
My interpretation of the court's entry granting summary judgment was it disposed of all of the claims, and I concede it does not say no just cause for delay or final appealable order, but my argument is it does in fact dispose of all the claims. The court removed it from its trial docket.
Well, except that the motion for summary judgment was not, that was granted in favor of the defendants, was not also a motion for summary judgment on their affirmative counterclaim. So in granting the motion, the court couldn't have granted it because it wasn't sought. In other words, the court didn't enter judgment in favor of the defendant on the defendant's claim for slander of title.
But I don't believe the court resolved the plaintiff's complaint that the May 5th, 18 instrument was enforceable under the statute of frauds. I think the court effectively disposed of that. And in that it then removed it from the act of the trial docket. My interpretation of the trial court's action was this case is over.
Well, maybe the trial court was mistaken if there still was a claim pending.
Well, I can only go by what the court put in its entry, Your Honor. And back to my position, if in fact the court has resolved that issue, that the May 5th, 18 document is unenforceable in under any legal analysis, I think the court has effectively disposed of plaintiff's claim. And as I outlined in my brief, I believe it is enforceable as a contract between the parties under the statute of frauds and based on substantial compliance with the land installment contract statute.
Let me ask you this follow-up. I just ask a quick follow-up.
Sure.
The slander of title action, there was an affidavit filed against the property, wasn't there? And I may be using the wrong number. And
No,
that's still there, right?
As far as I know.
So
I have not,
unless that claim is ultimately resolved, that issue is still pending in front of the trial court, whether the trial court realizes it or not. Because if the trial court had decided everything in defendant's favor, including the counterclaim, then the order would also have required your client to remove that affidavit.
I do not disagree with your analysis, Your Honor. But again, my interpretation of the trial court's action was he resolved at least all of plaintiff's claims for enforceability under the statute of frauds as a contract between the parties. My interpretation of the court's action is that has been resolved. If there is in fact a pending counterclaim, that would be Mr. Meyer's counterclaim based on that affidavit. But my interpretation of 250502 is that this order did in fact determine the action, at least on plaintiff's claims. And there was a further challenge to the sufficiency of the legal description that was included in the land installment contract. And again, based on established authority in the state of Ohio, a contract for sale does not need to describe the property with the sufficiency of a deed. It only needs to distinguish the property and establish it to the exclusion of other properties. And I think based on the attachments to the land installment contract, I think the property was adequately described for purposes of the enforceable contract.
Can you explain though what the point of RC 531302 is if it's not required to be followed?
Well,
and you're saying there's a valid contract and probably, but for that statute, you might be right. What's the point of that statute?
Well, I think the distinction being an instrument for the conveyance of property, which would be all of the elements of 5313, and whether or not a defectively defectively executed instrument for the conveyance of property is effective as between the parties as a contract for sale. And as I indicated, I think this instrument complies with the statute of frauds, 1335. And I don't think there's any dispute that the bars, in fact, executed it and accepted it, and later, after the fact, repudiated it. So, and there is, as I indicated, I believe, Supreme Court authority that a defectively executed instrument for conveyance of property is enforceable as a contract. So while it may not be sufficient to transfer title, it is enforceable as between the parties.
Would you like for me to reserve your time?
Yes, please.
Okay. So you're going to have 3 minutes when you come back on rebuttal.
Right. Thank you.
Attorney Meyer?
Yeah, just a few things on the facts. The Barth at the time, Mrs. Barth was 72, Mr. Barth was 77, and they didn't have their property on the market. They were approached by Mr. Hamilton. There's 2 parcels, as the court's aware of. One is in excess of 63 acres, 63 and a half, and the other one's 3.38. And these parcels, the auditor had valued at $458,000. Then this contract was prepared by an attorney that Mr. Hamilton went out and got. The Barth had nothing to do with it. And then he presents this contract. So he took it upon himself to see that this contract was properly done.
And all of those facts are actually clear in the record.
Okay. Let me, again, the court hit the key point that here is that, in fact, it did have to comply with the provisions of the land installment contract in the state of Ohio, because it was for the purchase of real estate. It would not be performed within 1 year of the date of the agreement. Under those circumstances, it's mandatory that one comply with 53-1301 and 53-1302.
And land installment contracts are recorded, is that correct?
That is correct, Your Honor.
Was this contract even recordable?
No, the problem is with this, and Mr. Niebert is not correct. There was not a correct legal description attached to this contract, and that's mandatory as one of the requirements under the land installment contract. What was attached? There was a deed that was given to the Barth some years ago, but if you look at the deed, it was for 38.74 acres and 79.84 acres in Harrison Township, which is well over 100 acres in Harrison Township, and the property involved here was just 63.5793. And it also, that deed also included 11.61 acres in Whitewater Township and not the 3.385 acres that is here. So it was not the deed to the property. The statute requires, the land installment contract statute requires a meets and bounds descriptions for the property. And it was not, there was not one attached. The auditor's parcel number is sufficient. It could not have been recorded. I mean, that's one of the deficiencies in this contract. It doesn't have the date stated. There is no interest rate stated.
Well, there is 0% interest rate.
0% if that's an interest rate. And the most important thing is what the trial court stated is that statute of conveyances, which is mandatory with the land contract, says that this contract needs to be notarized, and it was not. Now, you know,
now wasn't it days after the signing of this document? Didn't Mr. Hamilton come to the home and meet with Mrs. Barth, at which time she provided him a $500 check in return for deposit?
She refunded the initial $500. That's correct.
Am I understanding correctly that he walked away with that check in hand?
That's correct, Your Honor.
Okay, so what do we do with that fact?
Well, I mean, I think the court can find that he accepted, the contract was over at that point because he accepted the return of the down payment. And when he tried to send another payment later on, they rejected that. So basically, there is no contract besides all the deficiencies which exist when there's, with the land contract. And
Another thing I noticed interesting about this contract, and it comes from the language of the statute, that it has a 20-day provision to record it. And the Barths decided not to move forward, and they were still within the 20 days, were they not?
let me see, that was originally signed early in May someday, and then he came to their house on May 18th. That's correct.
Okay, so what would we do with that, if anything?
Well, again, it's another deficiency in terms of compliance. It was never recorded. It was not really recordable. It was not in recordable form. The recorder's office would not have accepted it because it didn't have a meets and bounds description. And there wasn't one.
Can you address Judge Zayas's question about finality of this judgment if your counterclaim remains pending? Because I assume you want that affidavit removed if you're entitled to that relief.
Yeah, we certainly do want that removed. Again, we didn't, after the court decided this matter as it did, we did not pursue that, but clearly we're going to have to get that affidavit lifted off of the record because it's a cloud on the title. So
Because that counterclaim remains pending in the trial court, or at least apparently remains pending in the trial court, and there's no 54B language in the court's entry, what's your position on whether we have a final order at this point or whether it needs to await finality of that counterclaim?
Well, Your Honor, it's still a pending issue. Again, as I indicated, from our perspective, we want to get that off the title. So that would be something if Mr. Nieberdien's client's not willing to do that, then we have to pursue that.
Anything further, Attorney Meyer?
I don't believe so, Your Honor. I would just add that there's no part performance here. I mean, there's some language in some of the cases.
Was there even pleadings of part performance?
No,
Of any
Your Honor.
reliance, detriment? Your internet connection has frozen. Attorney Meyer, I don't know if you can hear me, but your internet connection has frozen.
That land installment statute.
Your internet connection was frozen for about a minute and a half or so. So whatever you articulated is not part of the argument at that time.
Okay, well, I just wanted to say that there was not compliance with the statute. There's no part performance, so there's nothing to take it out. The statutory requirements and enable it to be enforced.
Thank you. Attorney Nieberding.
Yes. Again, to the issue of the final appealable order, it's my position under 250502B that this, in fact, did affect a substantial right in action, and I believe that the court effectively terminated all of my, or resolved all of my, Mr. Hamilton's claims. As to the court's inquiry, whether the document was recordable, I do not believe it was recordable because, number one, it was not acknowledged. And as the court has noted, under the land installment contract statute, that obligation falls to the sellers. And it is my position, based on the authority of Basil v. Vincello and Citizens Bank versus Dennison, quote, a defectively executed conveyance of an interest in land is valid as between the parties thereto in the absence of fraud. And the issue of fraud was not raised in connection with the summary judgment. So it's my position, at the very least, there's a genuine issue of fact, number one, whether this instrument, though not effective for a transfer of real estate under 5313, whether or not it's enforceable as a contract between the parties, because I believe it contains all the essential elements required for the sale of real estate under the statute of frauds.
So for clarity, is it your position that part performance is not required in order for it to be enforceable between the parties?
Yes, that is my position, Your Honor. I believe part performance comes into play when there is not a written document and the court is in reviewing an oral contract to create an agreement between the parties that should be in writing but is not otherwise in writing. I believe that we have a written document here, and I don't think there's any dispute that the bar signed it. And I believe it is enforceable as it may not be effective as a conveyance of property, but it is certainly complies with the statute of fraud. It is enforceable as a contract for the sale of property. We have all the essential terms, and my primary claim was specific performance. I was asking the court to enforce this agreement between the parties.
If there's no other questions from the panel and nothing further from Attorney Nieberding?
That is all I have. Thank you for your patience.
Thank you. Thank you both for your patience. And thank you for allowing us to take the case out of turn this morning. Thank you both for your arguments. And again, my condolences to the Barth family and their loss.
Thank you, Your Honor. Thank you.
And wishing you both a safe and warm afternoon. We
Thank
will
you.
take the matter under